And okay, I think we're recording now. Okay, everyone, thank you for coming out tonight. I'm Devon Graham. I'm one of the assistant state directors for American Atheists. I'm here in Tallahassee, Florida. And on behalf of the Humanists of Tallahassee and the newly resurrected SSA at Florida State University, I'm the new faculty advisor for them, and I'm freaking stoked about what we're going to do this year. COVID be damned. But I'd like to welcome you all tonight to our talk on religious discrimination at all levels of government um, with Nick Fish. And we have Josh Flashman here, who is the president of the SSA, and we'll hear more from him in a bit. But before we get started, there's a few housekeeping things. I think how we're going to run this is Nick is going to give an overview of the topic, and then Joshua and I will jump in and talk about the issues that are particularly germane to maybe what's happening here in Florida. And then we'll open it up to Q&A since we have people from all over on here. So we're going to remain muted until the end. If you have any questions that you just rather not say aloud, you can put them into the chat and send them to me privately. Just type question in all caps and I'll read that out loud. I guess that's it, housekeeping wise. So on to the reason why we're here. So Nick Fish is the president of American Atheists. He is our fearless leader and a native Michigander. Is that what it is? Michigander? Michigese? Michigander. Okay. And he's been an activist in the secular and political arenas for over a decade. He's been featured in a lot of news outlets such as the Washington Post and CNN, and even more fair and balanced ones such as Fox News. And he's been really amazing, especially when it comes to building coalitions with other secular and progressive organizations. So I'm going to hand it over to Nick now, and he's going to go from there.
Well, thank you so much, Devon, for the very kind introduction and for all the work that you do. For anyone who doesn't know Devon, I would certainly encourage you to keep an eye on her and get in touch with her. She is a really fantastic activist who does a lot for our community, but also just more broadly in the state, and is a really fantastic person to work with. We have a really fantastic team down in Florida, as we do all over the country, quite honestly. We have some really fantastic, volunteer activists who go do their day job and then come home and do their not day job, and then also find time to work with us, and sort of create time out of nowhere, either through force of will or some sort of bending of the space-time continuum, which I really appreciate. So I just want to thank Devon and Josh for making this happen and for inviting me. I'm really pleased to speak about this. I'm going to share my screen here. So you can hopefully see what's going on. Let me just give that a whirl. All right, that should be working. Everyone can see that, yes? Great. So I'm going to be talking about one of the emerging areas of the battle for religious equality in the United States, and that is this conflation of free speech with the right to discriminate. And so I'm going to start with just a quick overview here of what I'm going to talk about, the history of what's been happening, some background both on the legal front and just the current state of the law, as it were. Talk a little bit about some recent activity, things that have been happening over the last couple of years. Talk a little bit about the lessons that we've learned in both fighting the bad stuff and amplifying the good stuff. And then we'll have an opportunity for questions and some more specific conversation, like Devon said, that's more germane to what's going on in Florida and more directly applicable. So starting with the history of all this, what the heck are we talking about here? On the one hand, we have this tension between anti-discrimination protections and free speech. And that tension has kind of been around forever. And the level of that tension has ebbed and flowed over the years. And on one hand, the tension is kind of made up in a way. Like it exists, but we've resolved it. We resolved it years ago. And it's often framed as a religious freedom issue by mischaracterizing a commitment to non-discrimination and a commitment to protections for religious minorities, LGBT people, women, etc., as hostility or animus toward religion. which is really dangerous for us because it has some really troubling implications down the road. And what we've seen is laws, executive actions being taken that prohibit, and this is where it kind of ties in with the reason that Josh is here, and we're talking about this from an SSA perspective as well. And what I'm going to be focusing a lot on in this brief presentation is because it's a convenient target for the other side, but it's not exclusively targeted at institutions of higher learning. But what they're doing is using executive action and in some cases state laws to prohibit schools from having non-discrimination policies at all that apply to student clubs and organizations, or adding religious exemptions that create carve-outs and loopholes for certain types of clubs and organizations. So let me start there. Student groups and non-discrimination policies, the vast majority, the overwhelming majority of public colleges and universities and private colleges and universities have non-discrimination policies that apply to student groups. Even religious groups, or even religious schools, have these types of policies that say, if you're a student group, you can't discriminate on the basis of all of this list of protected classes, right? They can be linked to a general non-discrimination policy. So as I said, many public colleges and universities will have a general policy, just like employment non-discrimination policies, like anybody would, to make sure that they're in compliance with federal law, but they may go above and beyond that. And many states have adopted more stringent or more inclusive non-discrimination policies, especially for higher education. And then above and beyond that, many schools, especially if they're private schools and universities, have adopted even more inclusive non-discrimination protections. As part of the deal, when you're a recognized student organization, I believe FSU calls them RSOs. If you're an RSO, you receive a lot of resources from the school. You get funding, either in the form of direct resources. So here's a check. You get meeting space, you get promotions, you get recognized, you get like the imprimatur of the school. You get communication resources where you can kind of blast things out to the whole school if you want, and you get administrative support from the school itself. And as in exchange for that, part of the deal is that you agree to abide by the rules of the school. And this is kind of a common thread that goes through a lot of these issues. Is we're talking about groups that sign up for some type of service or some sort of opt-in. You don't have to be an RSO at Florida State to be a group on campus. You can be an unofficial group. You can meet if you want. You can be a religious group. You don't have to sign up for all these benefits. And in exchange for that, you don't have to abide by all of the requirements. And that's a lot of what this this does nationwide, and a lot of what we're seeing on this issue is a lot of groups want to have their cake and eat it too. They want all those benefits because they're pretty great, especially direct funding. Not having to worry about charging dues or whatever for your group in order to do some very basic programming is a pretty good deal. And so that's what this is all about, is they want the funding, they want the benefit, but they don't want to play by the same rules. They don't want to be treated fairly. They want to be treated special. And so here's an example policy. This is from Rutgers University. I don't know how well text comes across on Zoom calls, but it basically says that clubs and organizations may not deny membership to anyone on the basis of race, religion, color, national origin, ancestry, age, sex, sexual orientation, gender identity expression, disability, atypical, hereditary, cellular, or blood traits, marital status, civil unions, domestic partnerships, military service, veteran status, any other protected category. That is in line with New Jersey law. New Jersey law does protect all of those things. And it does, but it does exempt social sororities and fraternities from those rules, allowing them to discriminate on the basis of sex if they are exempt under the title of the IRS code that allows that. And as a result for that, they get all these other things, which is great. Florida State has a similar thing. They have this example constitution that says you need to include this non-discrimination policy that references back to the university's non-discrimination statement. I've highlighted it there in yellow. That basically says that you can't deny membership to anyone on the basis of all these protected classifications, many of which I just read. However, what's happening right now is a lot of states are introducing exemptions to this, or even categorical bans on student non-discrimination policies. And I won't read this verbatim, but the key point is down there at the bottom, and it says that groups are exempt as long as the discrimination is in alignment with their sincerely held beliefs, and complies with a code of conduct and furthers their mission as defined by them. Meaning that if they have sincerely held religious beliefs, for example, that LGBT people cannot be members of whatever Christian group it is, then it's fine for them to discriminate, as long as it's a sincerely held belief, as long as it is in alignment with a stated code of conduct, and as long as it furthers their mission in some way. And so furthering their mission would be, I don't know, glorifying God by being mean to LGBT people, which is always a funny way to show your mission, but what do I know? And so the way that they kind of jujitsu this and flip it around is they say that colleges and universities can't deny student organizations any benefits or privileges available to other student groups if those student groups want to discriminate. And so they frame it as, this attack that's happening on student organizations that they need to stop. They don't frame it as, we want people to be able to discriminate. They frame it as these groups are under siege, these groups are having something taken away from them, and we're going to stop it. And so it's this really, frustrating way of flipping this around to make them the victims rather than portraying them accurately as people who want to discriminate. These bills that are being introduced in states can vary widely. Many of them focus just on free speech. Many of them apply to a very limited set of groups, or they may apply to all groups. Some of the rules will say it only applies to, it'll say sincerely held religious beliefs, for example. And that's by design. These sorts of exemptions are generally sought by religious groups that want to be able to exclude people who don't conform to a pretty narrow definition or narrow window of belief. And the thing to keep in mind here is that these are groups that are funded by student activity fees. Their money doesn't just come out of nowhere. Every student in a higher education institution knows that you pay some amount of money. When I was in college, I think it was like $495 or something like that each semester that went to student activities, and that was sort of defined as any official student group with money being doled out by student government. And that has the effect of allowing or requiring students to have to fund groups that they themselves can't access, which is not a great spot to be in if you're a college student. Money's tight already, and now you have to support a bunch of groups that you can't actually join. And one of the things that has happened recently, this was a court case for this year, is the Supreme Court ruled in Bostock, which is a consolidated case of a number of different cases that all centered around discrimination on the basis of gender identity or sexual orientation. So Bostock was the primary case, but it included Zerba v. Altitude Express, and it included a sort of similar case called Harris Funeral Homes, which dealt specifically with gender identity. Bostock and Zerba were sexual orientation. This was a case that, at the time, it's a big case. It's an important landmark decision for protecting LGBT people from discrimination. But I think a lot of us were surprised that the court ruled in a way that was consistent with existing precedent. Like in a normal world where, making the best argument and having history and precedent on your side is what won the day, nobody should have been surprised by this verdict. But given the, shall we say, bad faith arguments that we've seen from many justices on the court around this issue, we were a little bit surprised. We were surprised it was a 6-3 decision, and we were honestly surprised that it went our way at all. But the one thing that you can say about Justice Gorsuch is, he is pretty consistent on certain things, and this is one of them. He wrote the decision for a 6-3 court. He really leans heavily on his stated judicial philosophy of textualism, basically saying, the text of the law should govern. The text said that discrimination, and our precedent has said that discrimination, but for some other reason, if it's for sex, we can point to that. And in this case, all of these are discrimination on the basis of sex. And it's, as I said, an extension of existing precedent, specifically Price Waterhouse versus Hopkins, which has been around since 1989 and is really what the advocates on our side on this case leaned on in the hopes that it would win over people or win over especially Justice Gorsuch on this. However, this wasn't a complete victory. Justice Gorsuch is a person who is very committed to religious exemptions and really likes religious exemptions. And this is a part of his decision that is sort of toward the end, basically kicking the door open for future religious exemption issues on this. But how these doctrines protecting religious liberty interact with Title VII are questions for future cases. Harris Funeral Homes, the people that were one of the cases that was argued as part of this, initially raised a religious objection, but then dropped it on appeal. They didn't raise the question as part of the case, so the court can't address it, essentially. But what he's saying is, so while other employers and cases may raise free exercise arguments that merit careful consideration, nobody in this case did, so we're not going to address it here. But it was very clearly, to those of us that were looking for it, an invitation for an employer to say, I have a sincerely held religious belief. I have a free exercise claim saying that I really can't hire LGBT people. I really can't hire trans people to work in my funeral home, to work in my, craft store, as a totally random example. And so I don't want to have to abide by this. And what he's saying is nobody raised it here, but, maybe you should try, which is sort of frustrating. And it goes back to this tension that exists between religious exemptions / free speech and protections, non-discrimination protections. This question, as I said, has been resolved previously. It's been resolved on racial discrimination questions going back to the 1960s and 70s and 80s. We've handled this 30, 40, and 50 years ago repeatedly. You can look up any number of the cases that have to deal with this, the Bob Jones University decision. You can look up, was it Piggy Palace, or is that right? There's a decision involving a barbecue joint that didn't want to have to serve Black folks at their barbecue joint. And so they said, well, we have a religious reason to support segregation. And the court said, no, it doesn't work like that. Discrimination is very bad, and it doesn't matter that it's that you don't want to do it. It's a generally applicable law. It applies to everyone. And racist discrimination is so bad that even if you had a good argument for a religious exemption to this, it doesn't matter because it's generally applicable and racism is bad. So this has been resolved as it relates to racism. However, in recent years, that is not necessarily, there's been some developments. Something that's more on point for schools, this goes back to 2010, is the Christian Legal Society versus Martinez. This has to do exactly with the type of discrimination that we're talking about on college campuses, where a group challenged non-discrimination policy at a law school where they didn't want to admit LGBT people. The court said this was what's called an all-comers policy, meaning that the school had a policy saying that if you wanted to join a group, you could. It means that student groups must take and provide services to all student applicants, regardless of their belief or some protected class. There was, some discussion in the case whether this was where this was a non-discrimination policy or something else. But since the case didn't really hinge on that, that it was a non-discrimination policy, and so they didn't really get into that. But they essentially said that because the school created a limited public forum, meaning that they've created all these groups where people can get benefits and speak out and whatnot, that they can apply certain restrictions on that ability. And in this case, that included the ability to require groups to serve everybody. And it's also going back to the funding question. It's important to note that there was a subsidy for officially recognized groups. If the Christian Legal Society hadn't said, hey, we want your money, they wouldn't have had to apply, they wouldn't have had to abide by this policy. And because they wanted to discriminate on the basis of belief, that doesn't fly. the court essentially dismissed the free exercise argument, saying that in seeking an exemption from Hastings across the board all comers policy, the Christian Legal Society seeks preferential, not equal treatment. It therefore cannot moor its request for accommodation to the free exercise clause. Free exercise clause requires equal treatment. It doesn't require special treatment. And that's something we've been hammering and talking about for years. However, as I said, this is 2010, which is sort of an eternity ago in free exercise and religious freedom litigation, which is really challenging for us. And so other relevant cases that are up right now, or that are older, are some of the ones on the screen here. I'm not going to go too far into those. And just I want to reinforce that this is a really rapidly developing area of the law. This is something that is changing essentially year by year, sometimes in pretty big leaps. It's possible that some of the recent decisions, especially Masterpiece Cake Shop, Trinity Lutheran, Espinoza, a case called NIFLA, which has to do with protesting at abortion clinics in California, I think is right, and Janus case that has to do with, I think that's the union's case. All of those having to implicate free speech in some way and could change something that's as recent as the CLS versus Martinez case. That case at the time was only a 5-4 decision, and that included Kennedy. So it's not really clear how things would shake out now. And by not very clear, I mean, it probably wouldn't shake out the same way. And so that's something for us to really be aware of and to be careful about when we're talking about potential litigation on these types of issues, and knowing or having any idea where the court's going to go. And so what we've been focusing on in this area has been state law, and to some extent administrative advocacy, working with administrative agencies like the Department of Education, but primarily fighting back bad laws at the states and trying to advance good laws at the states wherever possible. So on that note, let's talk about some recent state and federal activity. Here are some states, this is as of 2019, and not a lot has happened in 2020 for a variety of pretty obvious reasons. Not a lot of new policy has been introduced throughout the country. So, but I don't 100% know that this is completely accurate. So take this with at least one grain of salt. Things just aren't quite updated yet because of weird things going on this last year. The states that are in red had in 2018 prohibitions on student non-discrimination policies that went above and beyond, requiring basic adherence to the law. In 2019, bills were introduced in 11 more states, including Michigan, Missouri, Montana, Mississippi, South Carolina, Alabama, Arkansas, Iowa, South Dakota, Kentucky, and Texas, and passed in 5 states. These are the ones that are in blue. Yeah, the ones that are in that kind of weird light blue color. So that was South Dakota, Alabama, Arkansas, Iowa, and Texas. These bills kind of varied widely. The Mississippi bill, for example, would have allowed the governor to withhold funds from any public university if he disliked the way that they were promoting free speech. Texas, they kind of called it the Chick-fil-A bill. Probably not its original intent, but as it was crafted, it would seem to have prevented schools from restricting organizations that limit their membership in any way. So the Texas bill was originally intended as a way to shield Chick-fil-A from getting kicked off of college campuses. But what it actually would have ended up doing, because of sloppy drafting and potentially intentionally sloppy drafting, is it would have gutted the ability for any schools in Texas to restrict organizations that limit their membership in discriminatory ways. The 2 states with stars, Iowa and Pennsylvania, both have non-discrimination laws on the books in their state that conflict with these student laws, with these prohibitions on student non-discrimination policies. Obviously, that's not been resolved yet. We don't know, what would happen. At the federal level, there's been some activity as well. Last month, the Department of Education published a rule that would force private and public colleges and universities to fund student groups, even if they discriminate against prospective members. The rule goes into effect 60 days after it's published in the Federal Register, which was sometime around September 5th or 9th, depending on, they announced it on the 5th. I think I went into the Register on the 9th. The rule singles out religious groups for special treatment, essentially privileging religious organizations and religious speech in a way that is likely unconstitutional in our view. But if we can't get a court to rule that way, it doesn't really matter what we think. And it allows religious student groups to eject members who it finds out are LGBT, are single parents, have had an abortion, or any other discriminatory reason, and still receive student activity fee funding, which is why we think it's really dangerous. These bills and these actions, we've seen a lot of momentum behind them. They're being introduced and in some cases passing in states much more frequently. They've been tied to free speech bills. They call them campus free speech bills, but they're much more like campus license to discriminate bills. So they'll frame it as something about having to do with free speech, when in reality, it just allows groups to discriminate. These types of rules and laws have been promoted by groups like ALEC and Project Blitz. Project Blitz is something, obviously, if you pay attention to our work, you're probably somewhat familiar with. But it's also been promoted by groups like FIRE, which is the free, it's a First Amendment free expression group that has some complicated issues with free speech on campus, but also TP USA, Turning Points USA, which is sort of a right-wing conservative campus group that gets a lot of money from some very wealthy people on the right. And as I said, it's been tied to free speech on campus, and it's been kind of made a priority. So these bills and this type of activity have been introduced in ways as a response to this other thing, where they will talk about things like, someone being deplatformed. So like Ben Shapiro was disinvited from a school. We need to pass these laws, when in fact, the law also means that, non-discrimination policies can't take place, and they kind of loop them together, which is frustrating. Supporters of these bills will like to characterize them as, kind of attacking or taking on, liberal or politically correct colleges and universities, which is very appealing to a certain segment of that side of the argument. They'll typically characterize protests and walkouts or deplatforming as kind of like over the top, snowflakey things, and use it to draw media and public attention. And they'll typically characterize this as some new development that didn't happen before, which is, I think if anybody went to college in the 60s or 70s, would kind of be news to you that there wasn't protest on colleges and university campuses in the 60s and 70s. And again, framing this as a way of encouraging free speech when in fact it's not so much. There've been a few bills. There's been a bill introduced about this called the FREE Act, Free Right to Expression in Education Act, as well as an executive order by President Trump. And as I said, though, these rules and this legislation and the executive actions and now some of these court decisions are actually being used to limit the rights of students, oftentimes with chilling speech with threats of criminalization, denial of funding, crackdowns on colleges and universities, and attacking academic freedom and the ability for schools to set their own standards for appropriate behavior and appropriate conduct on campus. And again, these actions overlap with rolling back or eliminating prohibitions on, creating prohibitions on student non-discrimination policies and rolling back existing policies. The last Supreme Court case that I want to talk about that's coming up on this is Fulton versus Philadelphia. It's actually being heard the day after Election Day. It's being heard on November 4th, which is a Wednesday. So we don't anticipate that it will get a lot of coverage for some reason. But this case is about essentially whether a Catholic adoption and foster care provider can ignore Philadelphia's non-discrimination protections in its contract with the city. The adoption and foster care agency will not place kids either for adoption or foster care with same-sex couples or single parents, and that doesn't jive with Philadelphia's non-discrimination requirements in city contracting. The city elected not to renew their contract. They didn't cancel the contract. They just said, we're not going to renew it if you're not going to abide by the terms of it. And so the Catholic adoption and foster care provider sued, essentially saying that really innocuous statements by the mayor and one member of the city council amounted to animus or hostility to religion, and in our view is asking the Supreme Court to create a blasphemy law, essentially, that muzzles elected officials from voicing even, very banal criticisms of religion. The petitioners in this case, so the Catholic agency, cites a nearly 3-year-old Philadelphia Magazine article about then mayoral candidate Jim Kenney, who is now the mayor, where he was critical of policies of the Archdiocese of Philadelphia and the Archbishop of Philadelphia, but was otherwise approving of the Pope Francis, Catholic sister group, so nuns, and other Catholic orders and programs, saying they did a lot of great work. So it's kind of strange to say that it was evidence of animus. They also cite a 2-year-old Philadelphia Inquirer article where the mayor was quoted as saying that Philadelphia's archbishop's guidelines on implementation of a specific Catholic text were not Christian in his view. And then third, they cite a comment by the mayor where the mayor said, quote, "We cannot use taxpayer dollars to fund organizations that discriminate against people because of their sexual orientation or their same-sex marriage status. It's just not right." They also point to, that's the 3 comments by the mayor, and as you can see, those are hardly outrageous attacks on Catholicism. They also point to a city commissioner who, when the negotiations were ongoing to try to get the Catholic group up to snuff for the non-discrimination requirements, said that he urged the Catholic Social Services group to follow the teachings of Pope Francis, and that times and attitudes had changed, and that it wasn't 100 years ago anymore. So yeah, you can clearly see some just outrageous attacks on Catholicism by favorably quoting the Pope. Anyway, so we've learned some lessons in fighting these things and in dealing with all of this. Number one is to not make assumptions about who your allies are and who the people that might oppose this are. They don't necessarily break down on neat partisan lines or even on neat religious lines. These issues are complex, and the other side has introduced a lot of confusion into the discussion and clouded the issue, mainly by talking about this from a free speech perspective, which is something that we all agree on. Like I think that we all would characterize ourselves as in favor of free speech. And so, it's frustrating to see this issue being clouded in this way. The second lesson learned here is to engage partners, especially those who can speak clearly and eloquently on free speech concerns, and groups that can sort of blunt attacks or blunt characterizations of this as an attack on religion. So you want groups like the ACLU or Interfaith Alliance or campus interfaith groups who are strong advocates on those issues and can talk about them genuinely. The last part is to engage student groups, make sure that you have, if you're fighting back on something like this, identify allies that are student groups and assume that the other side will do the same. And so if this is a discussion that's happening at FSU, make sure student groups know what the stakes are and what's going on here, and, push back against misleading characterizations of what groups want to do. For example, Betsy DeVos, who is the Secretary of Education, in her announcement about this Department of Education policy, essentially said, hey, listen, all these groups want to discriminate. LGBT groups want to discriminate. Atheist groups want to discriminate. And all of the LGBT groups and the atheist groups were like, what? No, we don't. What are you talking about? And so, they're characterizing this as protecting these groups, when in fact, we all want to serve as many people, have as many people in our groups as possible, so that we can expose people to new and different ideas and challenge assumptions. And the way to do that is to talk about the impact here. The other side is really good at finding sympathetic parties on these cases, just like Little Sisters of the Poor on the contraception case, Catholic Charities on the Fulton case and other things, and something near and dear to FSU hearts, Jack Denton, the student who was fired or whatever as student body president by the Student Senate. It's not just about making the best argument, and I know that that's a frustrating thing for our side to hear sometimes, that we think we have the best facts, we have the precedent on our side, we just need to make the best argument, and the things will fall into place. Well, that's not always the case. It's, in fact, right now it's very rarely the case. It's really important to find the best messengers, and usually those are students for these types of bills. Don't repeat their framing. This isn't about free speech, it's about discrimination. is a really important way to think about these things. It's not about free speech. It's about giving special treatment to religious groups that want to discriminate. And then the last piece of this is to focus on inclusivity and pluralism as a value. That's an important thing that is part of being a college or university student, is to explore identities, to learn more about yourselves, to have your preconceptions and your stereotypes challenged. And people change throughout college and university, and being exposed to different perspectives is an important part of the student experience. And we want students to be able to do that. And so shutting students out of groups short circuits that entire enterprise. And that's not a good way of protecting free speech. In fact, it's a way of stifling free speech and stifling development of students. So that's something that's important to focus on as well. So with that, that's about 30 minutes, which is about the amount of time I wanted to spend on this. I'm happy to have a little bit more discussion, and then we'll have some questions. So I think we wanted to discuss some stuff with Joshua and Devon first, and then we'll do questions.
Yeah, Josh, do you want to go?
Yeah, so I don't think I've spoken yet. My name is Joshua Flashman. I'm the president of the Secular Student Alliance at FSU. And you touched on it a little bit, but specifically with Jack Denton, the situation we're dealing with is that he was removed by a vote from his position as the Student Senate president after he made statements in the Catholic Student Union group chat, basically calling, not basically, but he said it directly, but calling Black Lives Matter and other racial justice organizations as anti-Catholic for supporting grave, like in his words, grave evils like LGBT plus rights and women's autonomy stuff.
Josh, hold on. Let me stop you for a second. Do you have a better mic? Can you speak more directly into your microphone? I'm having a hard time hearing you. I don't know if I'm the only one.
Sorry. I don't really have a better mic, but I can try to move it closer.
You sounded fine earlier. I don't.
Come back to me and I'll see if I can fix it.
Okay, great.
Okay, I'm on the spot. So you mentioned Bostock, the Bostock case, which is like specifically for employment, but that doesn't necessarily cover education or university, correct?
Right. Well, so for Bostock, the language that's implicated in Bostock is Title VII of the Civil Rights Act of 1964, the definitions of which carry out through and ripple through many other parts of the law, including education, housing, things like that. So our feeling is that it likely is implicated everywhere else as well, that those definitions are consistent because they are, it's sort of identically phrased elsewhere. And, the issues that we're dealing with, the questions are essentially the same. And so we think that it likely will be the case, but who knows? But yeah, I would say 95% of the case, we are 95% sure that the standards will apply across the board. Obviously, it would be better if these rules or these specific non-discrimination protections were protected explicitly, but a Supreme Court ruling, gets us close to that, especially in a court where even replacing Ginsburg, it's still a 5-4 decision, even if, and we assume Amy Coney Barrett would not be on board with that particular statutory interpretation. So it's likely the case, but it's hard to tell. So having explicit protections, something like the Employment Non-Discrimination Act and at the federal level would be great. And also it's important to note that many states have more explicit protections than what is covered in the Civil Rights Act. So like New Jersey, for example, has a really robust non-discrimination law. It's called the LAD, the Law Against Discrimination, that covers discrimination not just in employment, but also in things like business transactions. So if you get thrown out of, not just a public accommodation, but even a private contractual thing, where, like, for example, American Atheists tried to hire an electrician, and the electrician came in, gave us an estimate, and then called us back and said, "Oh, I didn't know you guys were atheists," which is weird. And I didn't know you guys were that atheisty. It's very strange. And so I can't work for you. And so we filed a complaint, and it was very interesting because the people at that particular government agency were very excited. They very rarely got that type of complaint, but it is something that's covered under the New Jersey's LAD. And so, yeah, like you can be pretty inventive. You can be much more inclusive in your state laws than and much more easily pass those types of laws, which is what we're sort of advising and what we're working in coalition to do, because it's much easier to move it in, a marginal state, a state that, where a couple of votes here or there can really make the difference, as opposed to in the United States Congress. So.
But I could also imagine there's going to be significant backlash because of Bostock. So I'm guessing that we're going to see more, trans kids in sports type bills coming through.
Yeah, and that's certainly the big one right now, is trans people in public accommodations, so bathroom bills, quote unquote, trans kids in sports. These are issues that are largely designed to undermine and divide. These are not really that contentious of issues. The student athlete groups are unanimous in saying that it's not a problem, and so it's sort of a solution looking for a problem, which is frustrating, because it's you're talking about kids. You're talking about 17-year-old kid who's being told, no, you can't wrestle, or you can't play baseball, or you can't run, which is in track, which is really frustrating. And it literally has life and death implications for these young people, who are already much more likely to experience discrimination, much more likely to experience depression, to experience a whole host of negative outcomes because of the discrimination that they face. And we're amplifying it and making it worse by codifying it in schools. Fortunately, most of them have been blocked. So the example that I can think of immediately is the Idaho bill. But yeah, we're going to see many more of those. It's really where the religious right has turned its energies.
Yeah, but I think they could also go after the people who accommodate.
Yeah.
People who are trans. Like, for instance, last year, Florida, it didn't go through, but it was called the Vulnerable Child Protection Act. They're trying to get through, which was going to make it a second-degree felony for any medical professional who treated a trans child.
Yep.
And the whole thing was that they're like, oh, well, you don't want these kids to have surgery at such a young age. And that was the thing. But it could also be it was so vaguely written that it could be misconstrued that like a child that went in for like a kidney stone, but they were trans, and the doctor referred to them by their preferred name or pronouns. They were then treating them as a trans child. So therefore, so I think that's one way they could get around
and that's
that.
the problem. Like, one of the things I mentioned in Texas was that the bill that was supposed to be about Chick-fil-A was so poorly drafted that they almost accidentally got rid of student non-discrimination protections. That's the case in a lot of legislatures, where they don't have the resources, they don't have the expertise, and so they take a model bill and don't change the right words or introduce additional problems when they port it over. There was I don't remember where it was offhand. It was one of the Dakotas, accidentally repealed all of their drug laws for a day until they fixed the law. This is not an uncommon thing. It happens. So for 18 hours, all drugs were legal in the state because they accidentally screwed up. Welcome to state legislation. This is how this works sometimes. So yeah, it's very frustrating.
I think Josh
has got his mic
back online.
Yeah.
He's got to unmute himself though.
Yeah.
Yep. I got another mic to work, so hopefully you guys can hear me okay now, right?
Great.
Yep.
Perfect.
Okay, perfect. So I don't think I introduced myself earlier. I'm Joshua Flashman. I'm the president of the Secular Student Alliance at FSU. And you touched on it earlier, but specifically with the Jack Denton situation. He was actually removed by a vote of no confidence. He wasn't removed from the school. After he made statements.
He also wasn't removed from the student senate. He wasn't even removed from
his elected position as Senate. He was just removed as the position of student Senate president. But he had made statements in the Catholic Student Union group chat, calling Black Lives Matter and other racial justice organizations like that as anti-Catholic for supporting, in his words, grave evils, such as LGBTQ plus issues and women's autonomy and stuff like that. And he was actually just recently, about a week ago, determined by a Florida judge to actually be forcibly paid for the position. So it's normally a paid position that pays minimum wage for 6 hours a week. And while the judge decided not to reinstate him in his position since he graduates in December, he did say that he wants to make it clear that this is not Like if he wasn't graduating, he would have more than likely put him back in his position. And that he made it so that the school is still required to pay him with student fees to do nothing, just for the purpose of existing. And there's even a chance coming up soon that I just learned about that he may actually still have a chance to be reinstated in his position through SGA court. And if the SGA court finds it as a case of a violation of his freedom of speech, that he could just get put back in his position right away and the current one just kicked out.
Yeah. And so just to clarify a couple of things here. So SGA court is the student government court. It's like an appeals thing. And for those of you that aren't aware, I don't know how closely folks are following this. Essentially what happened was he made, some inflammatory remarks. Student government, the other members of the student government said, this is not the type of person that we want running, being president, and voted no confidence in him. The reason that the judge paid him back pay and the motion or the decision that came down was on essentially like a temporary restraining order or a preliminary injunction, depending on, I don't remember which one it was, but a preliminary injunction essentially says, if you have a high probability of succeeding, given all the context, we're going to enjoin the school from enforcing negative things against you. And so one of the things that a specific harm that he had was he wasn't getting paid for this job. And it was $9 an hour, maximum of 5 hours per week during the summer and 6 hours or 7.5 during the term, something like that. And he said he would have worked all those. So they essentially are paying him, it's, adds up to like $500 or something, to back pay for getting kicked out. The reason that the judge did this is because FSU has sort of veto power. The administration has kind of the final say on actions that are undertaken by student government, where, if they're handing out money or they're taking action as student government, FSU, the administration of FSU has the final say. And so, what the argument was, and it's a tough one. It is tough because people have an ability, I would think, leaders, people who have an ability to pick their leadership, student groups. This is the whole question of what we're arguing about here is that, do people have the right? And it's interesting because the people that are supporting Jack's lawsuit are Alliance Defending Freedom, and their whole shtick is that Christian groups have a right to pick who their leaders are and who their members are, and they shouldn't be forced to have people who are so out of step with their values that they're not real Christians, and so we're going to kick them out. But at the same time, apparently the student government doesn't have the same right to pick its leadership, because that's what we're talking about here. You don't run for, correct me if I'm wrong here, Josh, you don't run for president of student government. You're elected by the student government, right? You're not elected directly by.
This is different from the Senate, from the president of student government.
This is the Senate president.
Yeah, the Senate president is elected by the Senate.
Yeah, and the Senate picks its own president. Yeah. And so essentially what the Senate said was, this person's values aren't in line with ours. They didn't say because he's a Christian. They said because he made these statements that indicate, again, that his values are not in step with ours, that he would not be a person that LGBT senators felt comfortable working with, or Black senators felt comfortable working with. We don't want him to be leading the Senate. We think he would be ineffective as the president of the Senate. And I've read the documents. I've read the complaint. I read the judge's ruling on the preliminary injunction. And what she said essentially was, we're not going to force him back into the position because it would be unworkable. His term ends literally tomorrow. So, whatever. They certainly wouldn't vote to bring him back as president, knowing what they know now. But because he was president and he was engaged in, whether you like the speech or not, he was engaged in constitutionally protected speech. And because the administration has veto power and the administration can make the final decision about whether or not to allow certain student government decisions to go into effect, they think that it's possible that he would prevail in court. Now, again, that doesn't necessarily mean that he would, but it's an incredibly bad faith argument on their part, just based on, sort of how I'm characterizing it here, where they want, on the one hand, to say student groups that are given the imprimatur of the administration, that are given formal recognition, they shouldn't be forced to have people in their group even, or, certainly leaders of their group that they disagree with, they should be able to kick them out, whatever, if they disagree on religious issues. However, a religious person, if they disagree, and they didn't kick him out because he's Catholic, they kicked him out because he was being a dick to not being cool to LGBT people and Black Lives Matter, and they said it was out of step with their values. Because he was couching that in religious terms, that's an unconstitutional attack on his free speech. And it's the people making the exact same argument. And so that's kind of there's an inconsistency there. And yeah, the inconsistency does kind of cut both ways. But at the same time, we're talking about, he is still a member of the Senate. He was voted on by his peers in the Senate. The question and the thing that makes this particularly unique is, number one, that he was being paid. And so the judge sort of mentions that if he wasn't being paid, it might be a totally different story, because he is technically an employee of the university and faced repercussions as an employee of the university for engaging in protected speech. And because the university is bound by the First Amendment, that's partially why he would be more likely to succeed, according to this judge. If he wasn't being paid, I don't think he would have a leg to stand on, even if the administration had final veto power on actions of the student government. So this is a complicated case, but it sort of shows the hypocrisy, and it shows just how twisted all this is. If a person got up there and said, it's my sincerely held religious belief that, African Americans are genetically inferior, and, that women belong in the home, and, shouldn't be given equal rights, and blah, all this stuff, said some really, terrible stuff that is completely out of step with, the average American's values. Never mind, the liberal colleges. No, if this person was getting up there spouting out and out white supremacy and racism, we would probably want that person to be able to have a vote of no confidence and be removed from their position. But it's tricky when you're talking about employees of federal or state, in this case, state agencies. They are bound by the First Amendment.
So I would say my biggest question for you is, honestly, what would you recommend us to do regarding this? So what we've already done is we're working on, we've actually already finished a public statement that we're going to be publishing in the next week or so. Basically just talking about the situation and condemning the statements he made and stuff like that.
It's 9 o'clock.
But my question is there anything else that we can do specifically in this case, or even in the future, to prevent stuff like this from happening again?
That's a really hard question, because the particularities of this case are a little strange. Things that you can do moving forward is just, again, to reinforce your values and talk about how you want leaders that reflect the values of FSU. And his term, even if he were to be reinstated, his term's up tomorrow. So it's not like they can't force him back into his position. And the judge even said that. And thank you, Todd, for pointing out it's Alan Windsor. I thought it was Allison Windsor. I have Allison on the brain because our vice president legal policy is Allison. So I saw AL and I was Allison, yeah. Alan. So Judge Alan Windsor, it cannot force this guy back into his position. That's the judge specifically said it would really grind student government to a halt. It would make student government completely unworkable. And the state has a compelling interest in having a functional student government. And so, it could end up that they have to end up paying him $500 or whatever. And that's just kind of where it ends up. And, who knows? As for things, moving forward, is to more closely examine student government, make sure that you have people on the record for their values, and that you, ask them questions. Todd also points out that, he said the ACLU was anti-Catholic, and, he was just making really weird statements about all this stuff and sort of couching it in terms of his Catholic faith, rather than anything having to do with, any evidence. But, welcome to arguing with certain types of religious people. It's kind of the way it goes. And so, as far as things to do moving forward, be very clear about your values. critically examine people who are running for student leadership and student senate. Make sure that your people that you agree with are running for student senate. Get out there, be involved in campus. That's the crucial thing for this. As far as the court case, there's not a whole lot you can do because it kind of falls on the administration. It falls on FSU's administration.
I know that there is a group it's not the SSA, but there's a group of, I think, like 60 or so students that intend on having a protest this upcoming weekend regarding it.
Yep.
On campus. Is that the thing is, I don't even know if that's a cause worth supporting if there's nothing that can be done about it, if it's a final decision kind of situation. So I don't even know how.
It's not a final decision. This was a preliminary injunction. The case is still live. You can certainly protest about it, and the courts are not super responsive to public opinion, but they are somewhat responsive to public opinion, even if they don't admit it. But it shows, more importantly, it shows a commitment to the type of college and university that you want FSU to be, that you want it to be the type of university where people who say that it's bad that women can control their own bodies, or that it's bad that people are protesting, that Black Americans are being killed in the streets by the police. If you want the type of community where that type of rhetoric is unacceptable, then you should be protesting that. And even if maybe the way to deal with this, or something like this comes out in the future, is to have more of a pressure campaign from the student body, and urge this person to resign rather than the vote of no confidence. But that entirely depends on the specifics of the incident, because again, if the person is being paid, they are technically an employee of the school, which makes it a little bit more difficult.
Okay.
Because
it's never bad to protest. It's never bad to protest and be engaged. So if it's something you
of
care
course
about, get out there. It's important. You have a lot of different interested parties at play here, and so it's not just like, oh, the court doesn't care. That may be true, but the administration cares, and the administration wants the student body to be, and the student leadership to be productive. And so sending that message that we're going to be watching, and that these types of views are out of step with our groups, with the people who are there protesting, is great and is fine. You should totally do that. Sorry, Devon.
It's okay. So I'm wild and crazy. So I think what we're going to do is go to the questions in the chat and audience Q&A, because they're better questions than what I had. And Joshua, you're allowed to jump in if you have a good one too. But there was a question that, in a university setting, who could claim a RFRA-based exemption? The university, and how would a club with many student members make that kind of argument?
Yeah, this is one of the challenges here is RFRA only applies to federal law. Many states have RFRAs, but the Religious Freedom Restoration Act, as it exists in federal law, only applies to federal laws and federal agencies. Again, many states have state RFRAs. I believe Florida does, because it's Florida. But you can certainly check on states.atheists.org. We have a comprehensive list of all the states with RFRAs. It kind of depends on the specific wording of the bill. And so in general, RFRAs mean that courts have to examine rules and laws in a way that make sure that if religious practice or religious belief is somehow being burdened, that the law advances a compelling government interest, that it infringes on the religious belief in the least restrictive way possible, and that it doesn't single out religion for disfavor, essentially. That's sometimes a hard bar to clear, where courts will essentially say, well, we can imagine a less restrictive way of accomplishing this, so you need to do it again. You need to do something differently. In general, RFRA claims are only accessible to individuals who are being burdened in some way. However, in the Hobby Lobby case, they made sort of the novel argument that Hobby Lobby had religious beliefs that were implicated under RFRA, and that that was just so happened that those were the same religious beliefs as the owners of the corporation, and because it was a closely held private business, Now, there's no real limiting principle there. What do we mean by closely held? Hobby Lobby is an enormous corporation, for example. Does Ford Motor Company have religious beliefs? I don't know, maybe. A belief that, burning hydrocarbons is a sacrament, so we can't limit it. I don't know, maybe, who knows? Maybe Tesla. Tesla doesn't burn hydrocarbons, so that may be a poor example, but I'm trying to think of some company that is like closely held and owned.
They believe it's a sin to burn.
Right. Yeah, exactly. So allowing the burning of hydrocarbons is bad, is, a sin. So there's no real limiting factor there. So it's hard to say, whose religious beliefs are being can be protected by RFRA, or rather who can weaponize RFRA in this way. One of the things that we're recommending people do to sort of blunt the attack of RFRA is to pass what's called a Do No Harm Act. And Devon can talk to you about that, and we can work with you to work on that. But what it essentially does is it says, listen, RFRA is a statute. It's not part of anybody's constitution. It's not, RFRAs don't have anything to do with the First Amendment. In fact, they are explicitly a statutory thing. And what is a statute can be repealed by a statute or can be amended by a statute. And so what the federal RFRA, or Federal Do No Harm Act, does is essentially says anything under Title VII of the Civil Rights Act, any of these civil rights protections in the housing stuff, or employment non-discrimination, or education, or anything like this, are exempt from RFRA. So you can't raise RFRA claims, which essentially heighten the level of scrutiny of government actions. You can't bring RFRA into this issue because it's exempt. Because we believe that protecting civil rights and civil rights for people who have been discriminated against is important, and so we're exempting RFRA, or we're exempting those from RFRA analysis. This is the type of thing that would prevent stuff like there was a case in Arizona where it was called Brush and Nib, which was a stationery place that Phoenix passed a new law that said you can't discriminate in Phoenix on the basis of sexual orientation. And this company, the stationery company, said, hold on, we might someday have to sue, or because we do wedding stationery and wedding invitations, we might someday have to provide invitations for a same-sex couple, and we don't want to have to do that. And so they sued. Now, this is what's frustrating about the whole thing, is they were not harmed in any way because they had not been subject to any enforcement action. They had not been forced in any way to conduct, to create stationery for a same-sex wedding. They had not been, discriminated against at all. And yet they still were able to go into court and get a positive decision, even though they clearly didn't have standing. Standing is a requirement that you have to show harm in some way. And it can't just be hypothetical harm. It can't be sort of arm's length, well, this might happen harm. It has to be actualized harm. And, when we go to court and say, hey, this giant cross that you're spending taxpayer money to keep up is violating the Establishment Clause, a lot of times groups get thrown out and say, well, you're not really being harmed by that. Just encountering it every single day when you go to work, and the knowledge that your tax dollars are going to pay for it isn't enough. That's not a particularized harm. So sorry, you can't sue about this. But, the rules are different when you're religious, apparently, which is really frustrating. And that's what happened in Arizona. And so if Arizona had a Do No Harm Act, it would exempt these types of ordinances from analysis under RFRA. And so that's what we're recommending people do. In general, it would probably be the leadership of the group or the group itself. So it would be something like the Christian Legal Society or Campus Crusade for Christ, or Fellowship of Christian Athletes that would file the lawsuit and would raise the RFRA claims, just to answer your question, John. And then, a club, like I said, can make the arguments because the club under Hobby Lobby can have religious beliefs and doctrine.
There's a question that I think is like something that could happen. It's interesting that could happen in the near future, about what means of redress exist for students and student groups in response to local and federal restrictions on irreligious students who are denied funding or status under the DeVos Department of Education.
Yeah, so if you're denied funding or status, that's a very well settled legal doctrine. And in fact, there are federal laws that have to do with equal access on campuses that apply. And so you would very easily win, I think. If things were normal, you would very easily win that case. The issue isn't so much that non-religious groups are being denied funding or recognition. That very rarely is what's happening. Usually all that takes is a letter from us or from FFRF or from the American Humanists Association or Secular Student Alliance saying, hey, you probably didn't realize that you're really breaking the law here and will likely be sued and will lose if you refuse to deny this, or if you refuse to recognize this secular group. So you should hop to and pull your head out a little bit and sort this out. And they do most of the time. This is not something that we've had to file any lawsuits about in years, thankfully. It just takes sort of a nasty gram to fix. The bigger problem is that religious groups are being given special treatment. Rarely is it something as obvious as they're getting recognized and you're not, or they're getting money and you're not. It's that you have to follow the rules and they don't. And it's kind of frustrating because the rules that are in place are rules that you would follow anyway, right? It's not so much that you want to not follow the rules, it's that you want them to follow the rules too. And that's the problem. And that's a harder nut to crack because you have a harder time showing, your group has a hard time showing, again, particularized harm to get standing to sue, to force them to follow the rules. You try to sometimes do like a jujitsu double backflip type thing that we do with, the filing our IRS Form 990s, where we say, listen, we have to get audited every year. We have to spend all this time filling out paperwork. Churches don't have to. And what the courts have come back and said is, well, have you tried just not filing those and claiming to be a religion? And we've sort of come back and said, no, because we're not a religion. And they say, well, that's too bad. You should try being a religion then, which, is the whole point. And so, I don't think Josh's group, for example, is like, who we really want to discriminate against? Former Christians, right? Like that doesn't make any sense. You want people, if you have somebody come in and they're like, hi, I'm Catholic, but have questions about my faith. the response is not, get out of our group, weirdo. It's, oh, how interesting. We would love to talk to you about that. Right? Like that's the whole point.
We've actually been trying to make a space to get people that are religious involved, that believe still in like secular issues, like in especially like a political sense.
Right.
Just and like just the basic belief in separation of church and state.
Yeah.
And
that's the point.
Care less what you believe.
Right. And it's funny because, Betsy DeVos specifically, or the Department of Education in a fact sheet was like, we're not going to force LGBT groups to let straight people in. And it's like, do you know that these groups were called gay straight alliances for like 3 decades? Like it's literally in the name. And so, like that's what's so frustrating about it, is these are rules that we want to follow anyway, because we actually do value pluralism and we do value inclusion and diversity of our groups. And so, that's why like ceding the framing to them of, well, this is about free speech, this is about free association. Like, no, it's not. It's about discrimination. We don't want to discriminate. You guys do. So
this was another similar question in the chat. Like what actually legally defines a religion? Is it just the IRS status?
The IRS the IRS doesn't define religions. The IRS defines like churches, houses of worship. And it's this like multi-pronged squishy test where it's not like a checklist where you say you have to meet, 7 of these 10 things, but it is sort of like a general guideline where they say you have to meet many of these, which is like, this squishy requirement that some secular groups do meet. And there are like secular non-theistic religions out there, like the American Ethical Union, the New York Society for Ethical Culture. They are religious. They have the religious exemption. They do not have to file their IRS Form 990. They still are tax exempt, but they're churches. They are religious, and they specifically, if you talk to somebody at some of the ethical culture groups, and certainly with the American Ethical Union, they're very proud or very keen on that distinction, that they are not secular humanists. They are like congregational religious humanists, which is a difference. Groups like Sunday Assembly would get pretty close, I think, and would certainly be able to make a colorable claim to a religious or a house of worship style exemption where they don't have to fill out all the paperwork and could still be tax exempt in the same way. And so it comes down to stuff like, do you have a doctrine? Do you have leaders that are trained in some way to provide pastoral care to your members? Do you meet regularly at a place? do you have like texts and stuff that you follow? Things like that. Do you sell a bunch of stuff is like a negative kind of thing, where if you're like, but if you publish like tracts and put out like literature and stuff, and you proselytize and you try to get new members, like that's a sign that points to, yeah, you're probably a religion. And so there, like the page, if you look up on the IRS's website, if you look up irs.gov and you say, show me the requirements to be a church, it's like this thing that says what I just said, where it's a giant shrug with like a list of 15 things. And it's like, if you meet most of them, probably, if you have questions, give it a try and we'll see what happens, is kind of how it works. And a lot of it is just done based on kind of the honor system, where if you file for it, most likely they'll grant it. The problem is not so much recognition as a church by the IRS. The problem is much more recognition of sincerely held religious beliefs on the part of the courts, where the courts have turned around and said, well, this Satanist or this Pastafarian or this whatever, it's a joke religion, and therefore it's not sincerely held. While on the other hand saying, this clearly mistaken view that this evangelical Christian has, that this particular birth control drug causes abortion, which it doesn't, that view, it's not for the court to say whether or not that view is accurate or whether that view is reasonable. It's not for us to say. They say it's sincere, therefore it must be sincere. That's Justice Alito from the Hobby Lobby case, essentially saying, well, we can't really question it, which is a load of bull, because RFRA, the federal RFRA, does require that the belief is sincerely held and that it is a burden on their religious beliefs. And now, as I think a lot of us know, under Hobby Lobby and under Little Sisters of the Poor, Little Sisters of the Poor essentially said this exemption from providing birth control isn't good enough. We also don't want to have to fill out the form that tells the government that we're claiming the exemption, because by filling out the form, it allowed their employees to claim or to get birth control at no cost from the government. And what they said was filling out the form was an abridging of their free exercise rights, because it made them complicit in the evil of birth control. And they didn't want anybody having birth control. Well, tough shit. But the courts were really tiptoed around that and were very hands off in analyzing whether or not it was a burden, like checking a box and filling out a form, a 1-page form. Really, that's a burden? Come on. But again, there's sort of 2 sets of rules right now. One set of rules for evangelical Christians or really conservative Catholics that have a particular set of views, especially on LGBT issues, on human sexuality, on birth control and abortion, and a completely other set of rules for anybody else, even people who are religious, even Muslims wearing headscarves, even Christian scientists who object to all types of medical treatment, Scientologists who object to mental health screenings, Jehovah's Witnesses who object to blood transfusions. I think if a Jehovah's Witness walked in and said, hey, I don't want to have to provide insurance at this McDonald's that I own because it covers blood transfusions, or I only want to provide insurance that covers blood transfusions, they would get laughed out of court. But because it's abortion, because it's birth control, it's seen as reasonable to have those objections. And it's the government picking winners and losers and saying, this is a reasonable objection to have. You over here, you Jehovah's Witnesses, you're a weird cult and we don't like you. So you don't get an exemption, even though the belief is just as sincerely held, if not more so, considering that, more than half of Catholic women use birth control, right? That's, yeah.
But I think what I just heard you say is atheist chick tracts.
Well, we used to have those.
That was going to be original.
there's one that I've seen that we have some where it's like this little booklet, and it says on the front cover something like, the total of, of God's revelation to man or something like that, and you open it up and it's completely blank on the inside.
It's a notebook. Okay.
It's like a little tiny book that says, the most important things that God has revealed to man in the last, 6,000 years. You open it up, it's completely blank.
All right. One more question in the chat. So are there similar problems like this in the EU, and how is this type of issue seen under their laws?
I don't know. I'm not an expert on EU law. It's a great question. I don't know the answer, unfortunately. The EU, one thing to keep in mind about all of this is other countries do religious freedom differently than us. They do secularism different than us. There are very different approaches that seem really weird to us that accomplish, their articulated version of secularism. A place like France has a really compelling and strong separation of church and state, going so far as to say that like religious symbols don't have a place in public life in certain ways. So if you're a government employee, you can't wear a cross, you can't wear a headscarf, you can't do those sorts of things. There's like a registry of official religions in France, and as part of that, you have to essentially agree to preach in French, right? These are like, that's really foreign to us. But then there are other countries that have things like, is it the Netherlands? I think it's the Netherlands, Belgium, where they have these sort of like vertical integrations of religion, where every religious group, if it has official recognition, gets certain benefits from the government. Norway has this sort of thing as well, where they have state funded, the churches themselves are state funded. They get a certain amount of money per member, essentially. The churches, each religion gets a TV station, a radio station. Each religion gets a university. They have a university that receives government funding. And the humanists there are classified as a religious group. And so they receive this direct funding from the government as well, and have like a humanist university with faculty and students. And, it's a full-blown university. And that's like, we look at that and go, oh my gosh, like, what? that's crazy. Even in the UK, right? I mean, I don't think any of us would look at the UK and say, oh my God, it's it's a complete theocracy where rights are under constant siege and, whatever. But until recently, and I think still, humanist marriages are not given the same status as religious marriages. The Humanist UK sued about this, and compared to how fast court cases take in the US, it seemed like it really breezed through in like 3 weeks, where they got a decision, which for any of us who do litigation here is like, oh my God, 3 weeks, holy cow. They got a decision that essentially said, listen, the government is working on this, so you need to wait a little bit longer. The government said that they're going to fix this and give you equal treatment, basically. But essentially, what it said was, if you are religious, if you're a member of the Church of England or the Church of Scotland, you can just get married in a religious service, and it has full force of law. If you're a humanist and you want to get married in a similar service, it doesn't have any force of law. You still have to go to the town register and get somebody there to sign the paperwork, essentially. So if you want to have a ceremony that is meaningful to you not in a courtroom or whatever, or in the registrar's office, you have to still go back and do the other one to have it take effect. And we have that here in the US too, right? Where certain religious leaders are given preferential treatment for marrying people. And to get around it, you need like you go to the Universal Life Church and you do the online ordination, and now suddenly you can marry people in states where you couldn't. And groups that facilitate secular humanist celebrants. So the American Humanist Association has the Humanist Society, and the Center for Inquiry has the Council of Secular Humanism. They train people to be officiants. And so they have both filed lawsuits over the years, and varying levels of success. They did win in the Fourth Circuit. I think that's I think that's Michigan, and Ohio. They did win up there, where they said, hey, listen, yeah, we'll allow secular celebrants who have been certified by the Humanist Society and humanist celebrants who've been certified. So it can't just be anybody, which is still kind of annoying for us. But it's a step in the right direction. We'll recognize those marriages just like we would with anybody else. But in a place like New York, you have to be on a specific list, and you have to jump through a bunch of hoops. So even if you do the ordination thing, the online ordination, you have to get like a special version of things in order to get married in New York using those same rules. However, New York has the New York Society for Ethical Culture is specifically listed as a group that can ordain people to do marriages. But if you're not a member of the ethical culture, you're just a sort of generic humanist, it doesn't count. So, this isn't like a red state or blue state problem. This is something that's sort of a leftover vestige of, old timey stuff when, you can have that riverboat captain do your marriage, but you can't have, your friend who wants to help you, or who you want to officiate your marriage for no reason because you're just signing a document, right? Like, who cares? But yeah, it's sort of weird in that way. But yeah, in Europe, it's hard to say exactly what the rules are because the EU has different views on religious liberty, has different views on religion, has different views on free speech even, that are very different from our own. So,
all right, we're up at 9:30 here. Does anyone have any questions they want to say aloud, or
if you want to unmute them? I don't know if any of them have any that they want to.
God.
Mary has raised her hand. I think I can unmute Mary.
Hi.
Hi.
I don't really have a specific question, but I just wanted to say hi. So I'm one of the national committee leaders for Secular Student Alliance this year. I'm also the chapter president and founder of the Montreal chapter of Secular Student Alliance. So Josh and I are actually, he's my boyfriend, so we've supported each other a lot through this. And,
we met through SSA like 4 years ago.
Yes.
Well, thank you for all the work you're doing. That's great.
Yeah, we actually met through SSA. Thank you. But I just really wanted to say thank you for coming on. When he told me that he was able to get you to come on, I was very happy for him. I think this is really great, and I'm just really happy. I've obviously been staying very much on top of the issue with Jack Denton, helping with drafting the statement a lot. Yeah. And I think you mentioned a bit about how in France the secular laws are way more, I guess, extreme, strict, however you want to say it, in terms of wearing religious symbolism or anything associated with religious connotations when you're working in a government position. And that's actually something that's happening in Quebec right now. It's called Bill 21 in Quebec. Yep. And it's a very contentious topic that, in my opinion, has put a lot of unnecessary weight and unnecessary. I think it has painted secularism in a negative light that it really doesn't need to. Yeah. So that's when you said that's like very foreign to us. I was like, I'm an hour away from the border, and I am American. I'm from Florida as well. But it's very interesting that to some people it may be a very foreign concept, but I'm living through it every day.
Yeah, it's I'm familiar-ish with that measure, and yeah, it is. We have sort of our own little mini France in our backyard with Montreal. I'm from Michigan as well, so I'm sort of more familiar with Canadian things than the average person. So being literally in my backyard, right? And yeah, it's really tough because there's a very specific like sense of religious neutrality that people want to enforce in French culture. In like there's like an essential Frenchness to things. That anything that kind of gets in the way of that in France is, something that people are like, no thanks. Like your first loyalty needs to be to France. Like that's a key component, right? Of like French identity is literally French identity. Yeah. And that certainly has carried over into Quebec. And, it's certainly one of the reasons that, like there's a entirely different political party in Quebec, right? That's like, what we should do? Not be Canadian. we should be. We're from Quebec, right? Like everywhere else in Canada, I spent a lot of time in Ontario, just being literally next door to it. Everybody in Ontario is like, yes, we're Canadian. Yeah. Nobody's like, I'm from Ontario. It's I'm Canadian. You go to Montreal and it's like, I'm from Quebec. Like that's, and so it's just a very different like sense of secular identity and like a prioritization of, where you put your emphasis and things that undermine that are viewed very suspiciously. And, I don't want to say like, it's hard. I think we can make value judgments about like, okay, maybe this feels like a bit too far because, one of the complications here, right, is for somebody like where they do not like the burqa ban, like the burqa ban is one thing, but like the hijab ban is another, where, there are like ex-Muslims who will tell us like, no, we absolutely like it's a symbol of oppression. It's not good. But there are also ex-Muslims that say, and that, have the experience of, well, on the other hand, it makes it really difficult for somebody who is like on the edge, who is like in this really repressive structure, if they're being forced to wear hijab, and they're like really under the thumb of somebody who's forcing them to do that, they then can't get out and like participate in public life in any way, which only forces them further into isolation, which is really challenging. And so you're like dealing with all these balances of competing interests, and like what you want to emphasize and what the best route is to maximize freedom and liberty for individuals. And I'm certainly not advocating, protecting religious feelings. Sorry that your religious fifis have been hurt, but on the other hand, we do want to make sure that, women, if the goal is to maximize participation in public life of women, I don't know if a full-blown hijab ban is the way to go, because it has all these unintended knock-on consequences, which make it very difficult for women to participate in public life and to be full members of society in a meaningful way. So.
Right. Also, I think it's very Western centric to assume that, women who wear hijab obviously are somehow forced or oppressed into doing it. I personally know a lot of people who wear it, out of their own will. There's a lot of women of other religions who also wear veils, either full-time or sometimes, or at various sliding scales for different reasons. So I think it's certainly a contentious issue. And just a final thing that I guess to point out without keeping everyone around for too long, I think my main, criticism of the Bill 21 situation in Quebec is that their idea of what it means to have, in France's case, French identity, or in Quebec's case, Quebecois identity, is very white Catholic normative, right? Mm-hmm. These are all largely historically Catholic regions, and what it means to present normally and what it means to present in a secular way is almost determined by, what a typical French or a typical Quebecois Catholic person looks like, right? Yeah. Mm-hmm. Like, for example, a head veil or hijab isn't necessarily inherently religious. It could be a cultural practice as well, but It's a cultural practice that most Quebecois or French Quebecois or Catholic Quebecois would deem foreign or threatening, or like you said, threatening to the Quebecois identity.
Othering, yeah, it's definitely othering.
So I think that is a piece of it, right? Yeah. Yeah,
totally. And which is interesting, because if you ever look, if you want, want to talk about head coverings, whenever people go visit the Pope, speaking of Catholic normative, you go visit the Pope. The Pope requires, or Vatican rules require, that if you're a woman, you wear a headscarf. Like, it's so funny to be like, oh, this is an attack on, French essentialism, and it's like, you guys are Catholic. What are you talking about?
Yeah. So I even know like more traditional Catholic churches will, like, women will wear, headscarves even to mass every week. Yeah. But somehow
and if you're a woman you're visiting the Vatican, you're technically, you should wear black, and you're not supposed to wear pants. You're supposed to wear a dress, and you have to have your shoulders covered and your arms covered, and you're supposed to wear a head veil. And it's like, wait a second, why? It's interesting that, people aren't losing their minds about how that's, hostile to French secularism. It's interesting who the targets of that rhetoric are. Is what I'll say.
Definitely. I think in trying to start Secular Student Alliance in Quebec, one of the biggest pushbacks I constantly would get is, why would you advocate for something like this? Like, because I think a lot of people in Quebec also see, you know, measures like that to be, you know, culturally oppressive or alienating to other cultures that are not, you know, French normative or Quebec normative, and they obviously find that problematic. And, you know, and I had a lot of criticism and pushback of, oh, is this what you guys want? You guys just want to like erase religion out of existence, like you guys want to take away people's ability to express their religious identities, which in my opinion is not what secularism is about. Like, I don't think if my public school teacher was wearing a hijab or wearing a cross, like I would be traumatized or somehow religiously doctrinated forever. However, I would be upset if my public school teacher started, you know, preaching or making me read the Bible or the Quran or whatever else.
And there's certainly like different prioritization levels and different like expression. Like the American expression of secularism is very different from other places, and we can certainly, you know, hash that out. But it's always interesting, and it's something that we have to just be thoughtful about, and not just say, well, because this is how it is in America, that must be, you know, how it is. Like the First Amendment, our version of the Establishment Clause, like does not port neatly to anything else internationally. It's just a very different thing. So it's just something to always be conscious of. And, you know, the fact that we're able to have those discussions and hash that out and engage thoughtfully in the competing interests here, because I think, you know, a secular society where nobody feels excluded is the goal, right? Or is one of the goals. And how do we accomplish that? Well, in many cases, the French have said part of the way to do that is that civil servants should sort of present like this neutral, like, you know, blank slate of Frenchness, right? When they're being public servants. In the United States, we've certainly allowed a more integrated viewpoint of like, you can integrate some of your personal flavor and your personal views into doing your job, but not too much, right? And then in other places like India or Nigeria, there are like explicit, you know, parallel court systems set up for people of different religions that have the like version of the law that applies to only their community. And then there's, you know, Pakistan, where like that version of the law applies to everyone, even though the Constitution may say it shouldn't. But, you know, like, so that's, you know, there are very different views, and we can certainly say, hey, yeah, the way Pakistan does this doesn't work, and hey, the way it's being done in Nigeria doesn't work. Hey, the way it works in India is not really our preference, and here are some problems, and we should talk about those. And, you know, and so there's like this sliding scale, like you said. So anyway, it's the sort of thing we can talk about. If you're interested in international stuff, you can just go forever because there's so much, right? And that's why it's important to talk about universal values and universal human rights, which, you know, is how we want to frame this stuff internationally. I'm not an expert in international law. I'm barely an expert in American law. But I'm, you know, what's the know enough to be dangerous, right? Like that's, you know, I have people who are much better at some of that stuff than me that I rely on for advice. And so that's how that works. But on international stuff, that's why we're members of Humanists International, because they literally have people, you know, who are experts in international human rights law, who have PhDs in international human rights law and are international human rights lawyers. Like that's who they work with. So we can kind of point to them and say, hey, what's going on here? So.
Okay.
Thank you so much. This is an interesting discussion. Sure. Thank you so much for this.
Yeah, it's great.
All right. I think that's it for tonight. Okay. Thank you again, Nick, on behalf of the Humanists of Tallahassee and the SSA at FSU. Hopefully we'll do more like these, more of these co-sponsored events in the future.
Yeah.
If I can.
Oh, Tony, go.
If I can say something, Nick, you mentioned at the beginning how valuable Devon is. We here in Tallahassee, with the Hot Group, are really, really proud and glad to have Devon here with us. And as for Joshua and Mary, we were looking for a secular group, a student group, and that used to be at FSU, but we're very, very glad that you guys are here now, and we can work together and doing whatever we have to do in this community.
Yeah.
Thank you, Devon, for everything you've done, and thank you, Nick, for presenting.
Devon,
making a very intelligent, very interesting presentation.
my experience working with Devon is she takes praise and like positive accolades very well, and is very happy to receive them.
I'm really good at it.
Yeah,
I'm really good at it.
yeah.
Okay, I'm stopping the recording now.
Yeah, now she's like, I'm done. Get out of here. You're all kicked out.